The First Lady of the United States just made a move that legal experts are calling potentially disastrous. In attempting to shield herself from a lawsuit, she may have opened the door to something far more invasive, being questioned under oath about where she actually lives, how much time she spends with her husband, and whether she's been fulfilling her duties as First Lady. This week, Melania Trump hired one of the world's largest law firms and filed to move her case from New York State Court to federal court. It's a classic legal maneuver designed to delay proceedings and potentially get a more favorable judge. But there's a catch. To succeed with this strategy, Melania Trump will have to prove she's a resident of Florida, not New York. And that means she could be forced to answer questions about her lifestyle, her tax returns, her time at the White House, and even her son's college enrollment. Today, we're examining this high-stakes legal chess match, the strategic miscalculation that may have just occurred, and what happens next in one of the most unusual First Lady lawsuits in American history. To understand why this matters, we need to review how this case began. In October 2025, journalist and author Michael Wolff received a letter from Melania Trump's attorney demanding that he retract statements linking her to Jeffrey Epstein. The letter threatened a lawsuit seeking over $1 billion in damages unless Wolff apologized and retracted within 6 days. Instead of complying, Wolff did something unexpected. On October 21st, the exact day of the deadline, he filed his own lawsuit against Melania Trump in New York State Supreme Court. Wolff's lawsuit invoked New York's anti-SLAPP law. SLAPP stands for Strategic Lawsuit Against Public Participation. These laws are designed to protect people from lawsuits intended primarily to silence criticism through intimidation and the threat of expensive legal fees. By filing this type of lawsuit first, Wolff gains something powerful: subpoena authority. Once Melania Trump is officially served with the lawsuit, Wolff can compel her, her husband, and others in their circle to sit for depositions and answer questions under oath about their relationships with Jeffrey Epstein. There was just one problem. Wolff struggled to actually serve the lawsuit on the First Lady. One process-serving firm declined to work on the case, saying they wouldn't serve the First Lady of the United States. Another firm tried, but was unable to complete service. For weeks, the case remained in legal limbo. Melania Trump had not officially responded to the lawsuit because she had not been officially served. Then, in late December 2025, everything changed. Melania Trump hired DLA Piper, the third largest law firm in the world, to represent her. The firm assigned a partner who previously clerked for Supreme Court Justice Neil Gorsuch. And on December 29th, her new legal team filed a notice of removal, attempting to move the case from New York State Court to federal court in Manhattan. This move has significant strategic implications, and it may have been a serious miscalculation. To understand why this matters, we need to understand something called diversity jurisdiction. Federal courts generally cannot hear cases that belong in state courts unless specific conditions are met. One of those conditions is called diversity of citizenship. Diversity jurisdiction exists when the parties to a lawsuit are citizens of different states and the amount in controversy exceeds $75,000. The amount in controversy here clearly exceeds that threshold. The question is whether the parties are from different states. Michael Wolff is a resident of New York. He lives in Manhattan, works in New York, and filed his lawsuit in New York State Supreme Court. For Melania Trump to successfully move this case to federal court, she must establish that she is not a New York resident. She must prove that she is a citizen of a different state, in this case, Florida. But here's where things get complicated. While the Trump family owns property in Florida at Mar-a-Lago, they also maintain significant connections to New York. Donald Trump owned an apartment in Trump Tower on Fifth Avenue for decades. Melania Trump has spent considerable time there, particularly to be near her son Barron Trump, who attends New York University, which is located in Manhattan. For legal purposes, residency isn't just about where you own property. Courts look at where you actually live, where you spend most of your time, where you're registered to vote, what address you use for tax purposes, and what you've declared as your primary residence. And this is where Melania Trump's strategy may backfire. To prove she's a Florida resident, she's going to have to provide evidence. That could mean producing tax returns, answering written questions called interrogatories, and potentially sitting for a deposition where Michael Wolff's attorneys can ask her detailed questions about her life. If Michael Wolff's attorneys are allowed to conduct what's called jurisdictional discovery, the questions could be extensive and deeply personal. Where does Melania Trump actually reside? Is it Trump Tower in New York? Is it Mar-a-Lago in Florida? Is it the White House in Washington, D.C.? How many days per year does she spend in each location? Where does she receive her mail? Where is she registered to vote? What address does she use for her driver's license? What do her tax returns say? Has she claimed Florida as her primary residence for tax purposes, or has she claimed New York? If she's claimed Florida, when did she make that change? Where is her son Barron Trump's primary residence? He attends New York University, which is located in Manhattan. Is he receiving in-state tuition rates? If so, based on what residency? How much time has Melania Trump spent at the White House during the current administration? Multiple reports have noted her relative absence from Washington. If she's rarely at the White House and frequently in New York, does that support a claim of Florida residency? Where does she spend holidays? Where does she spend weekends? Where are her doctors? Where does she shop? Where does she socialize? Does she sleep in the same bedroom as the president? How much time does she spend with her husband? There have been numerous reports suggesting they maintain largely separate lives. If that's true, and if he's primarily in Florida or Washington, while she's primarily in New York, that could be relevant to determining her residency. Has she been fulfilling her traditional duties as First Lady? How many official White House events has she attended? How many state dinners? How many foreign trips with the president? These are all questions Melania Trump might have preferred never to answer publicly, but by filing to remove this case to federal court based on diversity jurisdiction, she's potentially opened the door to exactly this type of invasive inquiry. There's another significant development in this case. When Melania Trump's attorneys filed to move the case to federal court, it was randomly assigned to a judge. That judge is Mary Kay Viscachill. Judge Viscachill was appointed to the federal bench by President Donald Trump in 2019. She was confirmed by the Senate with a vote of 91-3. Judge Viscachill has ruled in favor of the Trump administration in several notable cases. In 2023, she ruled against Manhattan District Attorney Alvin Bragg when he tried to block a congressional subpoena. Bragg was prosecuting Trump for alleged falsification of business records related to payments to an adult film actress. House Judicial Committee Chairman Jim Jordan issued a subpoena to a former prosecutor in Bragg's office, seeking testimony about the investigation. Bragg sued to block the subpoena, arguing it was an improper attempt by Congress to interfere with a state criminal prosecution. Judge Viscachill sided with Congress, ruling that the subpoena was issued with a valid legislative purpose and that the former prosecutor had to testify. More recently, in 2025, Judge Viscachill denied Columbia University's attempt to sue the Trump administration for cutting its federal funding. The university argued the funding cuts were retaliatory and violated its constitutional rights. Judge Viscachill ruled against Columbia. Earlier in her judicial career, Judge Viscachill dismissed a defamation lawsuit against Fox News and Tucker Carlson. A former Playboy model who alleged an affair with Donald Trump sued Fox News, claiming Tucker Carlson defamed her by calling a payment she received a case of extortion. Judge Viscachill ruled that Carlson's statements were rhetorical hyperbole and opinion commentary, not actionable statements of fact. He wrote that viewers would understand that Carlson's show involves exaggeration and non-literal commentary rather than stating actual facts. So, Melania Trump has drawn a judge with a favorable track record from the Trump family's perspective. However, judges are bound by the law and legal procedure. Even a judge predisposed to rule favorably must follow established legal standards. The question is, how broadly will Judge Viskachil allow jurisdictional discovery? Will she allow Michael Wolff's attorneys to ask extensive questions about Melania Trump's residency? Or will she limit the scope of inquiry? That remains to be seen. But under federal rules, parties are generally entitled to reasonable discovery on jurisdictional questions. If Melania Trump is claiming she's a Florida citizen to establish federal jurisdiction, Wolff's attorneys have a right to test that claim. From a strategic standpoint, why would Melania Trump take this risk? There are several potential advantages to being in federal court rather than state court. First, federal courts often move more slowly than state courts. Filing a notice of removal immediately pauses the state court proceeding.